The Ghostwritten Ecuadorian Judgment. Ecuador is plagued by rampant judicial corruption. In its Ecuador human rights reports, the U.S. State Department has repeatedly emphasized the susceptibility of the judiciary to bribes for favorable decisions and resolution of legal cases, and on judges parceling out cases to outside lawyers who wrote the judicial sentences and sent them back to the presiding judge for signature. Plaintiffs' lawyers were captured on film discussing this widespread judicial corruption and how they could take advantage of it.
All the judges here are corrupt.
They're all corrupt. It's their birthright to be corrupt. Why? Because they get paid so little. You know, it's the culture. It's disgusting. And the only language that I believe this judge is going to understand is one of pressure, intimidation, and humiliation. And that's what we're doing today. We're going to let him know what time it is.
Incontrovertible evidence now proves that plaintiffs' lawyers successfully exploited this judicial corruption by ghostwriting an $18.2 billion judgment against Chevron. 6 different judges presided over the Lago Agrio litigation between May 2003 and March 2011. Judge Zambrano ultimately issued the trial court judgment, also known as the sentencia, on February 14, 2011. The record in this case spans more than 215,000 pages, and as one presiding judge remarked to Daryl Hannah in an outtake from the movie Crude, it could take a year to read the record.
Dios mío.
This is all the Chevron Texaco case.
You've read all of this?
¿Ya ha leído todo usted?
Poco, no mucho. El juez que dicte la sentencia tendrá que leer todo esto.
So the judge that gives the final judgment has to read all of this.
Oh my gosh. That could take
Mucho leer.
more years.
Sí, podría dilatar más, dice. Leer todo eso.
Sería un año, no sé, pero tiene que él leer y él es el que dicta la sentencia definitiva.
Yeah, the judge that gives the final judgment is going to have to read all this. It might take a year, I don't know.
On December 17, 2010, Judge Zambrano issued an order stating, "The evidence period is declared concluded and the record is requested so that judgment can be issued." This is typically when Ecuadorian judges first begin to review the record. On January 31, 2011, little more than 6 weeks after the close of evidence, Judge Zambrano told reporters that he had reviewed 1,500 notebooks of documents in the Lago Agrio court record and explained, "I have about 500 notebooks to go." Each notebook contains approximately 100 pages. Thus, in just a 6-week period, Judge Zambrano claims to have read over 160,000 pages, with more than 50,000 pages remaining unread. In the remaining 2-week period before the judgment issued, Judge Zambrano would have had to read those 50,000 pages and draft a 188-page single-spaced judgment. Dr. Keith Rayner, a psycholinguistics expert who specializes in human reading rates and reading comprehension, concluded, "It would have been impossible for Judge Zambrano to have read and fully comprehended all of the material contained in the Lago Agrio record in the approximately 8 weeks between when he started reviewing the materials on December 17, 2010, and when he rendered a verdict in the case on February 14, 2011. Internal documents produced by the plaintiffs' lawyers and consultants prove that they spent years secretly preparing the Ecuadorian judgment. In December 2008, plaintiffs' lead lawyer Pablo Fajardo called a meeting with all the teams to develop a plan to obtain a trial judgment in 2009 that would be favorable and significant. As Fajardo explained, "We have Correa, the court, and U.S. politics. It's now or never." In a June 2009 email exchange, Fajardo informed Stephen Donziger that he was assigning Brian Parker, an intern with plaintiffs' legal team, research for their legal alegato on the judgment, but without him knowing what he is doing. 2 weeks later, Fajardo circulated research to the plaintiffs' legal team about the use of a trust instrument to disperse judgment proceeds. Strings of text from this research appear word for word in the Ecuadorian judgment. A few hours later, Fajardo circulated an Ecuadorian Supreme Court decision to the plaintiffs' legal team. In his email, Fajardo implied that the decision should be used in their final trial brief, known as the alegato, and in the Ecuadorian judgment. Friends, this is the judgment in the Viuda Petro-Ecuador case. The arguments by the magistrates are very interesting. I think they serve us well for our alegato and, worth reading. Text from the decision is quoted at length in the Ecuadorian judgment, but not the alegato. The plaintiff's lawyers circulated these materials in preparation for a key meeting on the outcome of the case and what to do, how much money to put in, how to distribute the items, and everything. The plaintiff's lawyers sought to control not only the outcome of the case, but the content of the Ecuadorian judgment to ensure its enforceability abroad. As one of the plaintiff's lawyers, Joseph Cohn, explained in an email, in order to be effective at all in developing a judgment that will be enforceable in the U.S. and elsewhere, we need to be involved in the preparation of the final submission and proposed judgment, the major task we have all agreed upon repeatedly our firm would work on. And though Cohn discussed drafting a proposed judgment, the plaintiffs never publicly submitted a proposed judgment to the Lago Agrio court.
The Lago Agrio plaintiffs never publicly, on the record, submitted a proposed judgment in Lago Agrio, correct?
No.
Notes from a September 10, 2009 meeting between the plaintiffs' U.S. lawyers list creation of final order as a topic of discussion. An Ecuador task list from that same meeting notes, structure of judgment. Cohn's law firm will continue to discuss and think about how to structure the judgment. Judge Juan Nunez was the judge presiding over the Lago Agrio litigation when the plaintiffs' lawyers began drafting the Ecuadorian judgment. While the plaintiffs' lawyers were drafting a judgment for his signature, Judge Nunez participated in recorded meetings in which he acknowledged that he would rule against Chevron no later than January 2010.
No, yo sabe clara cómo es. Usted dice Chevron es el culpable y el acto es octubre-noviembre de este año y máximo hasta enero de 2010 y el dinero es 27 menos como puede ser más. Ya, okay. Ya, más. Okay. Well, venden sus acciones en Chevron. Gracias. No, venden sus acciones.
After the recordings of Judge Nunez's meetings were made public, the plaintiffs' lawyers conceded in internal communications that the big problem is that the judge commits criminal malfeasance, and what is bad is that he commits criminal malfeasance when he talks about the judgment. It could cost him a criminal trial. It also looks bad that he is at this meeting supposedly attended by a government official. Judge Nunez promptly recused himself from the case once the recordings were made public. This delayed but did not derail the plaintiff's lawyers' plan for the judgment. By December 2009, shortly after Judge Zambrano first assumed jurisdiction over the case, Fajardo emailed Donziger, assuring him that plaintiffs would almost certainly fulfill their plan for the judgment. When you come, I'll tell you the details, which I can't share by email. I think the plan for the judgment will be fulfilled. I'm not 100% sure, but I'm 99.99% sure. 3 renowned experts have determined that portions of the Ecuadorian judgment were plagiarized directly from the plaintiff's lawyers' internal and unfiled documents and databases. For instance, portions of the Ecuadorian judgment are an almost verbatim reproduction of one of the plaintiff's lawyers' unfiled internal memoranda, known as the Fusion Memo. Forensic linguists have likewise determined that Judge Zambrano did not author the Ecuadorian judgment. Given the evidence and expert analysis, it is clear that the Ecuadorian judgment was ghostwritten in part or in whole by the plaintiff's representatives. Despite the fraud in the lawsuit, the corruption of Cabrera, and the clear evidence that the $18 billion judgment itself was ghostwritten, Ecuador claims the judgment is legitimate and that Chevron should pay. But Chevron remains committed to exposing the truth about the Lago Agrio lawsuit and ensuring that the perpetrators of the fraud are brought to justice.